Good morning. I am Craig Dickus. I am the principal of McCook High School, and I get the honor of welcoming everybody here this morning to McCook High School for today's proceedings of the State Supreme Court of Nebraska. Okay, this is truly a once-in-a-lifetime opportunity for many of us today, and so I'm really excited and really proud to see so many students out here in the crowd who chose to come here and be a part of this today. I honestly believe that this is something you're going to look back on in a week, in a year, and even a decade from now and say, man, that was one of the coolest things I got to do when I was at McCook High School. Okay, so good job, way to make a good choice, and very excited for all of you to be here today. Okay, now that being said, this is not fake, right? This is not a production. This is a real life courtroom today. Okay, so I'm excited to have all of you here, but please make sure that you give it the proper respect that it deserves. Okay, because like I said, hopefully this opens your eyes to possibilities out there for your future and gives you a deeper understanding of how our government and how our judicial system works. Okay, so again, very good job being here today. Please do your best to show the proper respect and enjoy the experience. Okay, a few reminders that I've been asked to pass along for the group. If somehow you manage to get in here with a cell phone, turn it off. Okay, I know that they did a very thorough check of everybody, but that is a hard and fast rule. Okay, so if you have a cell phone, turn it off. No phones ringing, no selfies with the court in the background, no recording, no Snapchats. Okay, no food or drink allowed in here as well. Okay, so if you brought something, again, do not try to access it. If you have a camera and are with the media or student media, please make sure you have spoken with the public information officer, Janet, which I know that you all have, so that you understand when and how to take the pictures. Okay, silence must be maintained during the court session. The lawyers are presenting their arguments here today that have worked long and hard to get here. If you have an emergency, okay, whatever that may be, you can get up and leave. Again, just please try to do so in as respectful and low-key manner as you possibly can. Okay. If you do leave, try to wait for the break between the arguments until the attorneys are finished to come back in. Okay, and so we'll have people at the doors that will tell you when it would be possible to come back in. So if at all possible, stay in your seats. Keep quiet as long as you can, but if you do have to get up and leave, that is okay. I would ask that we give a round of applause here in a minute for Judges Ann Payne and Pat Heng. They are going to come up and kind of give us a little introduction about what you're going to be hearing about today. Okay, so without further ado, Judges Ann Payne and Pat Heng. Judge Payne, I believe you are up first.
Hello, welcome to the celebration today that we have for Law Day here in McCook. My name is Ann Payne, and I'm a proud supporter of McCook Bison. I'm wearing my McCook Bison colors today, go Bison. And I'm also the county judge here in McCook. And for those of you who are not aware, May 1st is Law Day. The United States officially recognizes Law Day. It is meant to reflect on the role of law and the foundation of the country and to recognize its importance for society. President Dwight D. Eisenhower declared May 1st to be Law Day USA. In 1958, its observance was later put into law in 1961. The day is meant to reflect on the role and the importance of law in the foundation of this country and to recognize its importance in our society. The Nebraska State Bar Foundation, who also sponsors mock trial, which I know you folks have here in this school. And the judicial branch of the state of Nebraska have collaborated for many years to bring Law Day educational programming and resources to classrooms across the state. We are pleased to celebrate Law Day with you here today and want to take this opportunity to bring you a glimpse into the judicial branch of government a few days before the official Law Day on May 1st. Each year, the Nebraska Supreme Court visits communities outside of Lincoln to conduct oral arguments and celebrate Law Day. We know that Principal Dickus and Mr. Gross put a lot of planning into this visit, and we want to thank all of you here at McCook High School for hosting the court this morning. So if we can just give them all a round of applause. Was established by the Nebraska Constitution as the third branch of state government. The entire Nebraska judicial branch, along with the state's legislative and executive branch, mirror the three branches of our national government created through the U.S. Constitution. This morning, you will be watching oral arguments presented to our Nebraska Supreme Court, the highest court in the state of Nebraska. For those of you wanting more background on the path that today's two court cases took to get here from the trial courts to this appellate level, I'm going to introduce you to Judge Pat Hang, the district court judge here in McCook. Judge Hang.
Thank you, Judge Payne. I'm a recent resident of McCook. I went to Lincoln Pius, so we quite often came out here and played McCook. So as a young kid, I was out here. I am kind of the nuts and bolts of what's going to happen today. As Judge Payne indicated, the Nebraska Supreme Court is here. They're the highest court. They hear selected appeal cases, and you're going to hear two of them today. They've heard already a dozen cases this week on Monday and Tuesday in Lincoln. Typically, the Supreme Court and the attorneys here who've argued before, and I've probably been there a dozen times, if not more, there's maybe one or two people in the audience. It's usually just the lawyers. Now that things are on TV, the law clerks can sit and watch. So this is a huge deal, not just for the lawyers who are here arguing, but also for the court. You probably, if I added everything, it'd probably be 5 or 6 years of attendance at arguments in the Supreme Court. So this is a really big deal. But the court consists of 7 justices, the Chief Justice and 6 different ones. And the 6 justices come from different sections of the state. It's divided up, so the state's got representation throughout. And you'll see when the judges come out, they're males and females, so it's made up of both sexes. You'll see ages. I think our youngest justice just turned 40 a couple months ago. So we have judges in 40s, 50s, 60s, and I think our oldest judge may have just inched into the 70s a couple years ago. So, and I think one judge I think just turned 60 this week. So you'll see a wide range of ages too. So you got a bunch of experience. You've got judges or justices from across the state. What you're seeing today, we have mock trial people here today. Okay, and undefeated, is that right? Are you guys undefeated? And the justices heard that last night, so they know they're not before the McCook, or they're for the McCook undefeated mock trial team. So there's added pressure with that, and now the lawyers know that as well. So, but it's not going to be like what you're experiencing there. That's what you see on TV at trial, where you have witnesses, you have exhibits, judges making rulings on objections. What we're here today for is the appeal of those type of cases. So the cases you're hearing today, one of the parties was dissatisfied with the judge's ruling, and so they've appealed it. And the Supreme Court doesn't hear all appeals, but they decide which appeals they want to hear, and these 2 cases they want to hear. And sometimes us as lawyers didn't really know why they wanted to hear them, and sometimes probably today you'll find out why they want to hear it for the first time. But so the lawyers have prepared every part of their case to try to argue. During the process, the the only thing that the justices have, are what happened at trial. So those who in mock trial, all the witnesses who testify, they type all that up and give it for the appeal. They take all the exhibits for the appeal. It's called the record, and the record is what the justices review. So, so if one of the lawyers here thought, I should have said this at trial because it's a really good argument, or I should have, or so-and-so would have testified, they can't bring that up at this stage. It's just going to be what happens. So during the process of the appeal, or the arguments here, the judges, and interrupt's not the right word, but they will start asking questions of the lawyers. So the lawyers will start arguing their case, and sometimes when we're up here, we're arguing what we think the justices have us here for, and we learn very soon it may be a whole different issue. And so then the questions start, and they're not interrupting the lawyers. It's just part of the process, because the justices know what they want to hear, and they want to get the lawyer to that point. So don't think they're being rude or impatient with the lawyers, because that's not what they're doing. That's just part of our process. And unlike TV, you're not going to hear what the decision is today. What happens after today is the court sits down among themselves, kind of reach a decision with their law clerks. They do research of the law and kind of come to a conclusion. And several weeks from now, there will be a written decision that's issued across the state, and all the lawyers will get it. And that's when you'll find out what happened today. So, and again, I think, as Judge Payne said, the court's always open. You can always go down to the state capitol and sit in the Supreme Court and watch, just like you can come down to Judge Payne and I court down at the courthouse here and watch. It's always open, and I would encourage you, if you're in Lincoln and the court's in session, to take the time, because even though it may be an intimidating process, but to walk into the incredible courtroom, but to sit there and just listen to what happens, it is amazing. Just like, and quite honestly, if you go Judge Payne's court more than I, that you'll see a lot of things that are really pretty interesting of everyday, common day life. So without much more, I'll turn it over to the State Patrol, and we'll go up from there. All right, thank you.
Hear ye, hear ye, hear ye. The Honorable Supreme Court of the State of Nebraska is now open for the transaction of business. Draw nigh, all ye having business with this honorable court, and ye shall be heard. God save the State of Nebraska and this honorable court.
Thank you. You may be seated. And good morning to everyone, and thanks very much to everybody here at McCook High School and all of the citizens of McCook. We are grateful that you are willing to host us, so we greatly appreciate that. We will begin this morning with introductions from the court. I am Mike Havican, the Chief Justice, and now by order of seniority as to service on the court. The other members of the court will introduce themselves, and they will tell you where they are from, where their district is located.
Good morning. I'm Lindsay Miller-Lerman, and my district is centered in Omaha.
Good morning. My name is William Castle. I have the northeastern quadrant of Nebraska, and essentially my home is, for that purpose, O'Neill.
Good morning. I'm Stephanie Stacy. My judicial district is Lancaster County.
Good morning, I'm Jeff Funk. I live in Nebraska City. My judicial district is southeast Nebraska and south central Nebraska, 25 counties in total.
Morning, Jonathan Papik. My judicial district is in the Omaha area.
Good morning, I'm John Freidenberg. I'm the 6th Judicial District. That's the western 47 counties of the state. This is in my district, so I am happy to be back out here. And I was appointed out of Rushville.
Thank you, members of the court, and I should point out that the Chief Justice is chosen from the state as a whole. So with that in mind, our first case this morning is Kane versus Kane. Counsel, do you want to come forward and take your places at your respective tables here? So is it Mr. Baugh? Mr. Bowie, are you going to argue this morning?
Yes, Mr. Chief Justice.
Thank you very much, and you may approach, but before you start, Mr. Chipman, good morning to you also.
Good morning, Your Honor.
Do either counsel have any questions before we begin?
No, Your Honor.
Mr. Bowie, you may proceed.
Thank you, Mr. Chief Justice. If I can just start this time here. May it please the court, my name is Sam Bowie, appearing on behalf of the appellant Suzette Kane, along with co-counsel Lindsay Camplin. I would like to reserve 2 minutes for rebuttal if I could. The central question in this case is whether the Nebraska Grandparent Visitation Statutes are unconstitutional as applied. The appellant, Suzette Kane, filed a petition to establish grandparent visitation with her 3 grandchildren. The children's parents, Appellees Shauna Kane and Michael Leonard, who are divorced, objected to grandparent visitation and moved to dismiss the petition for lack of subject matter jurisdiction and for failure to state a claim. Shauna and Michael argued that the petition should be dismissed on the sole basis that the Nebraska Grandparent Visitation Statutes are unconstitutional under the Due Process Clause of the 14th Amendment to the United States Constitution.
Is that the reason the district court dismissed the case, or?
The district court ultimately dismissed the case for lack of subject matter jurisdiction, which is kind of a procedural issue I'd like to expand on here.
Counsel, did any of the parties below notify the Attorney General of the constitutional challenge, and if so, does it appear in our record?
Yes, Your Honor. I believe Mr. Chipman notified in the motion to dismiss the Attorney General that the constitutionality of the grandparent visitation statutes was potentially in question, and I believe that's as part of the motion to dismiss.
Has a 9E notice been filed on appeal?
A 9E notice? Not to my knowledge, Your Honor.
What is the impact of that?
I don't believe it really affects how we proceed in this case.
Will it affect how we proceed? Can we reach the constitutional issue you want to talk about without a 9E notice?
I believe that we can. I believe that we're not, or Mr. Chipman rather, the appellees, are not contending that the statutes are wholly facially unconstitutional, as would require the filing of that.
Whose obligation is, assume that a 9E notice is required for an as-applied constitutional challenge. Whose obligation is it in this situation where the district court holds the statute is unconstitutional and the appellant is arguing otherwise? In most cases that we see, the 9E notice is filed by the appellant because the appellant is the party contending the statute is unconstitutional. Here that's reversed. Whose burden is it to file a 9E notice?
I would contend that the burden is on the appellees, who in this case are challenging the constitutionality of the statute. And it's therefore their burden to provide that form and notice to the Attorney General.
And if they haven't, what's the consequence?
If they haven't, and assuming it is required, then I believe under the statute and case law, the appeal could be dismissed.
Or would we rather just look at the appeal based on the statute, on the presumption it's okay? The statute's constitutional till otherwise declared.
Correct, and I'd like to maybe expand on my previous comment. And when I said that under the law it appears that the appeal would be dismissed, in this particular case, we can actually deal with the merits of the appeal without reaching the constitutional issue, which brings us back to the subject matter jurisdiction issue decided below. The court below decided or dismissed the petition for lack of subject matter jurisdiction, with the only explanation being that the grandparent visitation statutes were unconstitutional as applied. And it seems clear from precedent from the U.S. Supreme Court even that a unconstitutional statute a statute can be entirely unconstitutional, and the court still has jurisdiction. In fact, this very court has decided in previous cases that the grandparent visitation statutes explicitly place jurisdiction in the district court. And so it seems clear that the district court had subject matter jurisdiction, and the court didn't reach whether the petition should be dismissed for failure to state a claim.
So you're saying everybody was at the right courthouse?
Essentially, yes.
Okay.
And it appears clear that the statute vests subject matter jurisdiction in the district court.
Counsel, before your time really expires, would you like to talk about the merits of the case at all?
Yes, Your Honor. Thank you. So, proceeding to the constitutional issue, the constitutional analysis boils down to one question. Viewing all evidence in the light most favorable to the appellant, do the Nebraska grandparent visitation statutes violate the appellee's 14th Amendment rights to the care, custody, and control of their children? The U.S. Supreme Court has not defined a specific test. However, when this court decided Hammett versus Hammett 16 years ago, the court articulated that a constitutional analysis of the non-parent visitation statutes centers around three principles. First, there's a presumption that fit parents act in the best interests of their children. Second, a fit parent's decision concerning grandparent visitation should be accorded at least some special weight. And finally, the presumption in favor of fit parents can be rebutted under certain circumstances. And the petitioning grandparent must prove by clear and convincing evidence a significant beneficial relationship between the grandparent and the grandchild, that it would be in the grandchild's best interests for the relationship to continue, and finally, that such visitation would not adversely interfere with the parent-child relationship.
So does your client have to show that the parents of the child are unfit in their determination not to allow her visitation?
No.
Properly?
No, Your Honor. The statute does not require a showing of unfitness. In fact, the statute we're applying here proceeds from the assumption that the parents are fit and that there should be special weight accorded to their decision on grandparent visitation, which can be overcome or rebutted in certain circumstances.
So, how would you rebut it in this case?
I'm sorry, could you repeat the
How would
question?
you rebut it in this case?
So in this case, it's rebutted through meeting the elements of the Nebraska grandparent visitation statute by clear and convincing evidence. That was this court's analysis in Hammett versus Hammett, that each element of the non-parent visitation statute is specifically crafted that when satisfied by clear and convincing evidence to meet these substantive due process concerns, that we are affording special weight to a parent's determination by showing that the visitation would not adversely interfere with the parent-child relationship. And so the statute provides a mechanism for a petitioning grandparent to rebut that presumption by meeting all the elements by clear and convincing evidence.
So in this case, if you were successful, what would you have this court do?
So I would have this court reverse the order of dismissal and remand this matter for further proceedings. And we can get past, in this case, it was a motion to dismiss. We can get past that stage. We can establish and flesh out a trial record, and we can really reach a decision on the merits, with the grandmother, in this case, having her day in court.
So the grandparent visitation statutes allow a hearing on the merits based on affidavit. And we have affidavits offered here. Do we have enough in the record?
Do we have enough in the record?
Do we have
is the
enough
question?
in the record to reach the merits? Did the trial court have enough in the record?
So I don't believe the trial court did. I think that we had affidavits, but we could have, gone to trial. We could have had testimony and other evidence. And I think we can get beyond here the motion to dismissal standard and just determine it on the merits under the standard elaborated in the statute.
Would it be error for a district court to determine a motion for grandparent visitation based on affidavits alone?
In this or you mean outside of the motion to dismiss context?
Correct.
I don't know that we are necessarily taking that position. I don't know that it particularly is the petition of the appellant that it would be error using affidavits only. But we would just like the chance to present that additional evidence back on remand.
What evidence would you be looking to present that you haven't presented already?
We would want testimony from witnesses and other exhibits of that sort. The sort of evidence to be presented at a full trial.
So, for example, who would these witnesses be?
So it could be the petitioning grandmother, the respondents, the children, anyone else who could provide relevant information to whether the Nebraska grandparent visitation statutes are satisfied. And if there are no remaining questions, I would like to ask that this court reverse the order of dismissal and remand the matter for further proceedings consistent with Nebraska law. Thank you.
Thank you very much. Mr. Chipman, good morning to you. We've got to work on the clock a bit here.
Good morning, Your Honor.
This is kind of audience participation here.
Members, Honorable Court, may it please the Court, my name is Dave Chipman. I have the great pleasure of representing the respondents in this matter, Shauna Kane and Michael Leonard, the appellees, as it may be before this Court. These are two fit parents, and there's no contest. They even conceded it in their argument. There's no contest. You have two fit parents, and you have no contest that neither of these fit parents want anything to do with the petitioner or appellant in this case.
Before you dive too deeply into the merits, I think you heard the colloquy of my colleagues and I with your opponent about a 9E notice. What's your viewpoint about that?
Your Honor, my viewpoint is that the appellees did everything they had to do at the trial court level, including providing the notice, and that I do not believe that it's on the appellee's responsibility to provide notice to the Attorney General under 9E.
Assume that we conclude to the contrary. How does that affect the way that we might dispose of this appeal?
If you assume that the appellee's responsibility is, if you assume that the responsibility is on the appellant, then I think you have to dismiss the case because the Attorney General wasn't properly informed. And if you find the same for the appellee, I believe the same is true, that the matter, but I don't know how you would remedy that other than possibly a rehearing of some sort, allowing the Attorney General an opportunity. But if you believe that the Attorney General required notice, then they're not here, and the appeal needs to be dismissed at some form or fashion. But again, we didn't bring...
9E talks about an obligation to serve the brief assigning the unconstitutionality of the statute on the Attorney General. Here, we don't have any party filing a brief assigning unconstitutionality, do we?
We don't.
So what do we do with that?
Well, there's a case called State v. Kelly, and I cite that in my brief. And State v. Kelly basically says, you know, they say, yeah, good for you, as I read it, for notifying the Attorney General, but you weren't asking for a declaratory judgment in this case, declaring the statute to be unconstitutional, and you're not trying to attack, you know, that this is facially unconstitutional, which we're not. So at the trial level today, no one's saying that this grandparent visitation statute, specifically 43-1802, is unconstitutional on its face. We're simply saying it's unconstitutional as applied. My position is, like the appellants, it's not necessary to notify the Attorney General at this stage. It was basically done by the respondents in the underlying case based upon the case of State v. Kelly as a precautionary matter. I considered 9E as we went forward. I believed, as I read that, there was no obligation on the appellee's responsibility. I also didn't think there was any responsibility on the part of the appellant to do it.
So how did constitutionality of statute get in the case at the trial level?
It got in based upon a motion to dismiss, Your Honor. And so the respondents in this matter filed a motion to dismiss, citing the Luley case of Illinois, saying that that the petitioner could not bring this action because he had two basically fit parents, and they had the right to not allow this visitation, and that there was no state compelling interest.
So in your view, I beg your pardon, so in your view, that went to lack of jurisdiction, right? But right, and if there were jurisdiction, you also filed, did you not, a 12B6 failure to state a claim?
I did, Your Honor. And so as I thought this case over, you know, there's a case that I think back in 2002 that came before this court. It's a Weeder versus the Central Community College case. And what that case says is, you look at the substance of the underlying motion. And what the substance of this motion is that two fit parents have the right to not allow grandparent visitation, and the state lacks a compelling interest to enforce visitation upon these two fit parents, and it's unconstitutional as applied to these two fit parents.
And all these arguments are made by reference to the existing statute on the assumption it's an okay statute.
Correct, right.
Thank
So
you.
the statute is presumed to be constitutional. However, again, we're arguing not that it's facially unconstitutional, we're arguing that it is unconstitutional as applied. And the one thing I want to mention as well before this court is, in their brief, in the appellant's brief on page 11, they actually state they don't want this court to decide it on a procedural matter. They want this court to, and I know they don't get it, nobody gets to dictate what the court does, obviously, but they want the court to decide it on the substance of the motion, which is, can a grandparent in Nebraska bring a grandparent visitation case with two fit parents, regardless of their marital status? Is there a compelling state interest to do so?
Can you bring it or can you win?
Well, and so I say you can't bring it. I say that you can't bring it if they, so the Troxel v. Granville case talks about fitness. There was no allegation of unfitness, and it's conceded by the appellant that they're both parties are fit.
So would you have to prove unfitness if you're the grandparent bringing this type of case in this situation?
Absolutely, Your Honor. They absolutely.
So you can bring it. You would have to provide evidence that parents are unfit and they're improperly preventing you from having the grandparent visitation. That would be the position, is that correct?
That's 100% the position, Your Honor. And so they, and like
Is it unconstitutional, or is it just an issue of proof?
Well, I agree wholeheartedly with the decision in Luley with the Illinois Supreme Court, which says that if you know, again, this is uncontested, two fit parents, you cannot bring it's unconstitutional to apply to these two fit parents because there's no compelling state interest as it pertains to these two fit parents, because there's no need for the state to intrude on these two fit parents to force them to have grandparent visitation. And that's what the Luley case says, and I think it's 100% the correct ruling in this case.
So let's go back to jurisdiction for a minute. Does that, regardless of the constitutionality, does that deprive the trial court of jurisdiction?
Well, that's a $1 million question, Your Honor. And so it has been the appellee's position that it does because they're not operating off a statute that is constitutional as applied to these people, so the defendants, and so there's no relief that the court could grant them because unconstitutional is applied. So then basically it makes the court's subject matter void. But I also want to mention, again, going back to the Weeder case, at the end of the day is they should have had to plead at least that these people were unfit. They didn't, and they're conceding they're not unfit. And so it also would qualify for a failure to bring a claim that which upon relief can be granted, because it is unconstitutional. I mean, two fit parents should not have the intrusion of a third party forcing a third party visitation.
Do you need to introduce a constitutional argument into this case to get the relief you seek? I mean, it seems to me your argument is there's two fit parents, and this is going to adversely interfere with the parent-child relationship between those parents, and it's not in the best interests of the kids. That's what it seems like your argument is. But doesn't the statute incorporate those very things? It says the court may, first of all, not obligated, but may grant grandparent visitation. And then the things the court is supposed to consider include best interests of the child and whether granting visitation would adversely interfere with the parent-child relationship.
So let me ask
so
you-
why do you need to bring the Constitution into this? Why can't you just say not entitled under the statute?
Well, so I think what you're alluding to, this is a clear winner regardless of how it gets decided. This is a case that in no way should the grandparent be allowed visitation. However, as all of you know who have handled family law cases, there is such a great intrusion upon anyone who goes through a family law case, upon the parties. Depositions, discovery, attorney, every part of your life. There is no need for the intrusion, and that's basically the only way I believe you get it kicked on a motion to dismiss is by stating and showing that it is unconstitutional as applied to these two parties.
If we find a blanket rule of unfitness for grandparent visitation, isn't that going to just significantly increase the intrusion in this type of cases? Because they're going to have to show unfitness, allege it and show unfitness before they can even say, I want to see my grandkid.
So Your Honor, you're talking about a case with two parents who are fit, right? And if you look at your case law, I can't find one other than the Mousy case, which was decided based on standing. So it's not, I don't think it's that frequent. You have two fit parents where the grandparent's trying to come over the top. But I want to say this as far as if someone tries to bring a case like this and try to show unfitness, I think that they're ripe for a 25-824, bringing a frivolous action, because you already have this court in a decree finding them to be fit, awarding basically a joint custody arrangement with these parties. And so I think that if someone comes in and wants to spend that time of trying to demonstrate unfitness, this is why they have counsel, right? To say this is not a good idea. This is probably a frivolous action. How can you show these people are unfit?
But the measure of when the unfitness would be judged would be at the time of the filing of the grandparent visitation petition, wouldn't it?
So they would have to allege, Your Honor, that they're...
Some change of circumstances.
Right.
That's possible, right?
Right, it is possible. They would have to allege the unfitness at that time, Your Honor, and then they would have to go on to somehow demonstrate the unfitness. However, again, I think anyone who's under Rule 11, would be hesitant for most cases to try to say these two parents are unfit, given how seldom unfitness is found on parents.
Let's assume hypothetically that we disagree with you and the trial court as to whether or not the trial court had jurisdiction. What should this court do then?
I think the court should look at the substance of the motion, and there is sufficient. And again, even the appellant is asking this court not to remand this case on a procedural ground. Is this? This is review de novo, and I think this court should decide the underlying principle, which is undenied that two fit parents cannot be held into court. It's unconstitutional to them, and this statute is unconstitutional as applied, and therefore the motion to dismiss is affirmed either on 12b6 grounds, but at the end of the day is that the court lacks. Basically, they lack the ability to grant the relief, which the appellant is seeking in this case, which is visitation.
Opposing counsel suggests that it should be remanded back for a trial. What's your position with respect to that?
Well,
Is there enough evidence in our record to decide this case now?
the only concern I would have at all, which would not be our client's concern, would just be a due process issue that they came with a temporary order, asking for temporary custody. Obviously, when you come for temporary custody, you bring all of your evidence. 43-1802 allows the court to decide these cases on affidavits. I think there's more than enough to show there's not clear and convincing evidence that's in the best interest of these children to go with grandma at any point in time. And so, to answer your question.
What happened to the custody issue down below?
The
What kind of a hearing did you think you were going into?
This hearing was dual purpose, Your Honor. It was on the motion to dismiss, and it was also on a motion for temporary visitation under the grandparent statute.
Temporary visitation, or was there a custody issue to be, you just made reference, I think, to a custody issue.
I was talking about the custody of the underlying case of the parties, Your Honor. In 2018, or maybe in 2019, these parties had a full on, I say parties, I mean my clients had a full-on custody battle, for lack of better words, before the court, which was decided that Shauna Kane would receive primary custody and Michael Leonard would receive parenting time, and they basically have an 8-6 schedule, quasi-joint custody.
I may be confused on the facts. The grandmother here never asked for custody. She just asked for visitation.
She asked only for visitation under the statute, Your Honor. And again, our position continues to be, just like in Lulay, the case Lulay of Illinois, that there's no compelling state interest when you have two fit parents who both find it is not their children's, ages 4 to 10 now, best interest to have any type of parenting time. And so what we're saying is that there's no compelling state interest to allow the intrusion at the end of the day.
Was there any in loco parentis allegations?
None. There was no allegations that she stood in the role of a parent. It was simply that it was in the best interest of the children that she granted over the objection of the fit parents to have parenting time. And so the judge in this case didn't even rule on the temporary order, simply dismissed the case, which was the right ruling, given the facts of this case. This case should never have been brought, but the point is that the Constitution, I mean, again, Lulay is 100% on point in the fact that you have two fit parents, and it's unconstitutional as applied to these people. Absolutely is, and I think that's conceived in most of the case law that you'll find. I've gone well beyond my time, so I appreciate this court's time a great deal. Thank you.
Thank you very much. Do we have any time for rebuttal? I'm afraid I'm.
No, Your Honor.
I think that, Mr. Bowie, we'll give you a minute for rebuttal anyway, because I think Mr. Chipman got a little extra time.
Thank you, Mr. Chief Justice. If I could, okay. So, counsel for the appellees here stated that there is no compelling state interest. However, this court in Hammett versus Hammett found that the state does have a compelling interest in protecting the well-being of the children in these grandparent visitation cases. The appellees point to Lulay versus Lulay from Illinois. However, that case deals with a completely different statute, and especially given the concern and level of detail.
Let me interrupt you here and ask you one more time. Do you want this court to send this back for further hearings at the trial court, or, as Mr. Chipman has suggested in your brief, didn't you suggest that this court can dispose of the case at this level?
The court could dispose of the appeal at this level by reversing the trial court's determination of lack of subject matter jurisdiction. However, appellant is asking that this court reverse the order of dismissal, remand, and then allow us to conduct discovery, obtain and present rebuttal evidence, material for cross-examination and impeachment, and basically have our day in court beyond just presenting affidavits at the motion to dismiss stage.
Thank you.
Thank you.
Counsel, thank you very much. That concludes arguments in Kane versus Kane, and you are excused. You can remain for the rest of for the next case, and/or we have normally a question-answer session after that, or you can leave, either. And the court will go on to the next case of the day, which is State versus $18,000. Counsel, good morning to you. Give me a second. Mr. Sipp, good morning to you, and you may approach, but before you start, Ms. Passel, you are also here. Do either counsel have any questions before we begin? Do you understand the timing system? You're ahead of me, but that is great.
When it beeps, I will stop.
Very good. Thank you, Mr. Sipp. You may approach and you may proceed.
May it please the court, counsel, I'm Bradley Sipp. I represent the appellant Christopher Bolden. The primary issue in this case is if there was sufficiency of evidence to forfeit $18,000 from a traffic stop. On August 1st, 2020, Mr. Bolden was stopped in Seward County, Nebraska for following too close. The officer noted that he was driving a rental car, that he had a radar detector and a cooler in his car that he had drinks in so he wouldn't have to stop. The officer invited him back to his cruiser and wrote him a ticket. Eventually, Mr. Bolden's car was searched, and the officers found $18,000 of cash wrapped in a sleeping bag in Mr. Bolden's car. The police seized that money, didn't write Mr. Bolden wasn't cited for a crime, and they let him go his separate way. The county attorney's office in Seward County, pursuant to Nebraska Revised Statute 28431, filed a suit to determine whether or not that money should be forfeited. Mr. Bolden then filed an answer or a claim against the money. A trial was had in which Mr. Bolden did not appear. The state did call a deputy, the deputy that made the stop, and he stated that he in fact believed that the $18,000 was to be used as drug money or to purchase drugs. And the reasons he gave again were that Mr. Bolden was driving a rental car, that he had a radar detector, and radar detectors are often used by people to avoid law enforcement. He also stated he had a cooler. Mr. Bolden had told the officer that he was going to Colorado from Richmond, Virginia to hike, that he was going to the Denver, Colorado and the Fort Collins, Colorado area.
Mr. Sipp, go ahead.
Had he made that sort of trip a couple of times before with a rental vehicle for about the same period of time, and what, if anything, do we make of that evidence?
Judge, he had made that trip at least twice before. Same kind of time frame, I believe, renting a vehicle for about 1 week, leaving Richmond, Virginia, going to Colorado, and then returning to Richmond, Virginia. The deputy would like to say that shows that he's somehow going to Colorado to purchase drugs and then returning to Richmond, Virginia. And the fact that Richmond, Virginia is a large city is one of the things that the deputy would point out that would make him believe that. I would say that shows us that he likes to go to Colorado, and nothing more than that.
Mr. Sipp, so far, your argument has focused entirely on the sufficiency of the evidence. But your brief, I understood to focus more on the burden of proof issue.
And yes.
Are you still arguing that the trial court applied an incorrect burden of proof?
I think this court needs to determine what the correct burden of proof is. The statute did change in 2016, and it changed from the case law had been beyond a reasonable doubt.
Why would the burden of proof not change when the statute changed?
So the issue here is that this is a criminal case. And so as a criminal case, beyond a reasonable doubt seems to be the correct standard. I understand that the legislature changed it to clear and convincing evidence.
So your argument would be that the statute is unconstitutional because it calls for a burden of proof lower than beyond a reasonable doubt despite the criminal nature of the proceeding?
My argument has not been that it's unconstitutional, but that the judge applied the wrong standard. I would submit to you.
But what leeway does the judge have to apply a standard other than the one set by the legislature?
And I would submit to you that in the past, the case law had been beyond a reasonable doubt.
But wasn't that case law based on a previous statute that said beyond a reasonable doubt?
I don't know. I don't know that the statute said beyond a reasonable doubt. I know that
assume that it did.
Okay, but I know that the case law did. But if it was and the statute changed, then, Judge, you are correct. The correct standard is clear and convincing evidence. But it's my argument that there's no nexus between these facts from this stop, the fact that he had a cooler and these different things, and he does have some criminal history, as the court knows, and the fact that this money should be forfeited.
Did you present any argument in your brief that there was an absence of a nexus between the facts?
I only stated in the brief that there was an insufficiency of evidence, that there was not sufficient evidence.
So if the prior statute said beyond a reasonable doubt, and the current statute, which you agree changed, says clear and convincing evidence, are you conceding that your first assignment of error lacks merit?
I would concede that, Judge.
Mr. Sipp, you've been talking about burden of proof, but the statute that we're talking about actually mentions 2 burdens of proof, and a much lower one if your client had shown up for the hearing. So if the person from whom the property is seized shows up for the hearing, all they've got to do is prove by a preponderance of the evidence that the property wasn't being used to violate the act, and they get it back.
Correct, Judge. It's a 2-prong approach. If they show up at trial, and of course, he did not show up at trial. I was not his counsel of record then. He was pro se. If he'd shown up at trial, he could have shown by a preponderance of evidence that that money or property was not going to be used to violate the act. He did not. So then it goes to prong 2. And prong 2 would be that the state would have to show, I think we've agreed now, by clear and convincing evidence that in fact that money was used to violate the act.
So is it a civil statute until it becomes more like a criminal statute?
Well, I think that's part of the problem, is that it's listed in Chapter 28, which is crimes and punishments. In the past, the court has found the old statute to be criminal in nature. Double jeopardy would apply. And so this is kind of this quasi-criminal and civil. Obviously, I would call it a civil forfeiture of this asset.
I beg your pardon, do we need to answer that question if we're just looking at the statute?
I don't think you have to answer that question. I think what
And now, so then you resume to your merits, and you're saying your client wasn't there, right? So the burden was on the other side, and they said what they said, and you're saying it's not enough.
I'm saying it's mere conjecture. What the officer said was mere conjecture. The idea that he was alerted to this, that somehow his professional knowledge, that the dog that was in the car didn't look like a hiking dog.
So was this admissible or objected to as speculation and conjecture?
All of those things were admitted into evidence because Mr. Bolden did not appear, and so the state simply presented their case to the district court.
Would we find in your brief an argument that the evidence was insufficient?
You would only find statements that it's insufficient. There is a very short, we're talking about a couple of sentences, that the evidence was insufficient to forfeit the money.
Is that sufficient to meet our requirement that assignments of error be both specifically assigned and specifically argued?
I believe that the issue would have been that again, it's the same, it ends up being the same argument as far as facts. It's the same facts that are in both briefs, and that is that there isn't enough evidence to show by clear and convincing or beyond a reasonable doubt that in fact this money was used to violate the act. And just that statement gives you the argument that in fact there's not sufficiency of evidence. And the same facts apply to burden of proof and if the evidence was sufficient or not.
The officer here gave a litany of reasons why he believed this money was tied to the distribution of drugs, did he not?
He did.
And you've addressed a handful of them, showing to basically attempt to cut the legs out from his reasoning. But isn't it fair to say that when the district court's reviewing this, it reviews all that reasoning as a group, as opposed to each one individually?
The problem here is, unlike other cases, State versus 1985 Mercedes, there, the owner of the car that lost the car, he wasn't arrested for anything. Crack cocaine was found in the car. A warm crack pipe was found there. There were other things that went along other than just conjecture. With
Did the
that,
officer testify about his training and experience and his knowledge that he's gained?
he did testify, obviously, at foundational purposes, all of the training that he had, drug interdiction training.
So the court heard that evidence, as well as the evidence of what was found in the vehicle, as well as what the officer's opinion was of what those facts meant based on his training.
And again, Judge, and it would be our position that it's just an opinion. So we would ask that the order of the district.
officer?
Yes. He wasn't an expert, and the things he was testifying about were mere conjecture. We would ask that it be remanded for further hearing. Thank you.
Thank you very much. Ms. Passel, good morning to you. You may approach. We're going
you. Good
to
morning.
reset the timer there.
Oh, good. Good morning, Chief Justice Heavican. May it please the court. My name is Lori Passold. I represent the state of Nebraska and filed the petition on behalf of the state of Nebraska to forfeit the $18,000 currency that was found in Mr. Bolden's possession in 2020 pursuant to 28-431. The issue before the court, as I saw it, was whether the proper burden of proof was applied at the trial court level, and the state believes that it was. As the court is aware, in 2016, the Nebraska legislature amended 28-431 and changed the burden of proof from beyond a reasonable doubt to clear and convincing evidence. There were other changes made to the statutory scheme surrounding forfeiture of property that's seized from people, and it's the state's position that the changes that were made at that time changed what this court has previously deemed to be a criminal forfeiture under 28-431 to a civil forfeiture.
Do we need to decide in this case whether the forfeiture is criminal or civil in nature?
I'm asking the court to do that. I think that if this court says, based on the scheme of the statute, even though it says clear and convincing, this is still a criminal in nature statute, there's potentially a problem because what do we do with, there's no beyond reasonable doubt. So I would ask the court to look to this and say, yes, the statute changed, and this is now a civil forfeiture.
Are there some sequelae or consequences to a pronouncement by this court that the statute changed from criminal to civil?
Yes.
Why do you want that for future cases, and what should we be leery of?
I think the consequence is that if the court were to determine that this is now a civil forfeiture rather than a criminal forfeiture, if the proceedings are brought pursuant to 28-431, and I want to be clear about that, because at the time that these amendments were made, the legislature also put into place a pathway for a criminal forfeiture. So the state believes that there are two pathways now to forfeit proceeds, money like this. The consequence, if this court finds that this is a civil forfeiture, using that clear and convincing evidence standard, is that the double jeopardy analysis when it comes to a companion criminal proceeding would no longer apply, or that would certainly be the state's position. I know that
That's
is-
the point of the question.
Right.
Why would you insist, to the extent that you're urging us to make a ruling and a distinction?
Would the distinction also affect our standard of review? And I'm sorry I interrupted your answer.
I think it might.
Just
and
cue mine up behind.
Sure, and I struggled with that when I wrote my brief, because it's my position that this is a civil forfeiture. If that's the case, the standard of review by this court is different. I believe it's de novo on the record on in rem actions. I believe that that's correct. I still think that the review by this court would find that the evidence was sufficient to uphold the court's determination at the trial court level. And perhaps the court does not have to make the determination that this is a civil forfeiture. Again, I understand on its face when the statute was modified, it now says clear and convincing, and I can just come up here and say, look, that is the proper standard that was applied in this case. I know that the court will also think through the prior precedent that this court has used in Franco and other prior forfeiture cases, using the analysis of whether a case is, or a statute is a civil forfeiture or criminal forfeiture, looking at the legislative intent, and if the legislative intent appears to be civil, is there a penalty that then puts it into a criminal arena? And again, that's where the state's position is that this all points to it being a civil forfeiture.
Assuming that the district court judge used the right standard, what do you think our standard of review is here? Perhaps you've already articulated that, but.
If the court finds that this is a civil forfeiture, I think the standard review is de novo on the record. I understand in criminal cases, the standard is different, and I've stated that in my brief. So I think that's one of the reasons why this court will be thinking about whether this is in fact a civil forfeiture or remains a criminal forfeiture.
Isn't the de novo on the record standard applicable in equity matters? If this
Yes.
were a matter of law, wouldn't we apply the clearly erroneous as to the facts and de novo only on the law?
That could be, and Justice Castle, I will acknowledge that I'm a criminal prosecutor, and so I don't think about the civil standards as much. I did think about it when I was writing this brief, but I was in the position of knowing what the court has previously said about the standard of review in the context of the court's prior findings that it was a civil case. So if I've misstated it, I know there's prior well-established case law in terms of the standards of review.
Prior findings that it was civil or prior findings that it was criminal?
Criminal.
Yeah.
Criminal.
You misspoke, that's why.
Sorry, no. I appreciate that. So again, I think that the legislative intent with these changes in 2016, on its face, it says clear and convincing. The legislature put into place, as the court is aware, a pathway to have a criminal forfeiture that can be part of the process at the time of sentencing if somebody is convicted under the drug statutes, specifically possession with intent to deliver, attempted possession with intent to deliver. That's a criminal forfeiture. That was a response, I believe, to this court's ruling in Franco regarding double jeopardy. And the court invited, or at least cleared the pathway for the legislature to make those changes in Franco.
Let's assume your opponent would argue that the placement of the statute or the retention of the statute in the chapter on crimes and punishments would, by argument, make it a criminal proceeding. What would your response to that be?
I know that this court and other courts of the United States Supreme Court have looked to the title of a statute or the code or the placement of that, but that's not dispositive. Certainly in the state of Nebraska, the title of a statute is determined by the revisor of statutes. It's not determined by the legislature. So I think that has very little impact on what the legislative intent of a statute is. The fact that it can be found in Chapter 28 again, should not be dispositive of it. I think there's a lot of other factors that the court needs to look to. Did the burden of proof change? It did. It's no longer beyond a reasonable doubt, and now it's clear and convincing evidence.
Your argument would be that its placement would not be dispositive, but you would concede, would you not, that when it was amended as amendment to 28-431, so that the legislature knew where this particular statute was going to be placed.
That's, sure. Yes, that's absolutely correct. But I think that placement in and of itself should not control that determination as to whether it's civil or not. Again, I've discussed the fact that there's two pathways. It's not just as it relates to drug money. At the same time, the legislature created those two pathways for child pornography cases. They did it for gambling cases, in which they amended the criminal portion of those offenses, creating the ability to forfeit through the criminal prosecution and or separately do that through a civil proceeding. Again, the burden of proof was modified, and
So if we get to the issue of sufficiency of the evidence, is there sufficient evidence that this money was used in violation of the act?
Your Honor, the state would argue to the court that there was sufficient evidence to find by clear and convincing evidence.
It's all circumstantial.
It's all circumstantial, based on, no drugs were found. The smell of drugs was found. Not only, or the officer himself could smell a faint odor of drugs on the food sealer that was found in Mr. Bolden's possession, that he would say was going to be used to seal food while he was hiking on his trip.
So isn't it possible, given the state of the record and these arguments, that our standard of review, assuming we would conclude it was a civil statute, might make a difference if we're reviewing factual determinations for clear error or reviewing them de novo?
I would argue not in this case. I think the evidence, even applying a different standard, would convince this court that the evidence was sufficient. And as a result, the state would ask the court affirm the lower court's ruling. Thank you.
Thank you very much. Do we have any time for rebuttal?
No, Your Honor.
Counsel, thank you. That concludes arguments then in State versus $18,000. And as I noted before, you are excused and you can leave if you wish. We are now going to have a question and answer session with the students and anybody who's here, and you can stay for that if you wish. Counsel, thank you very much. That concludes arguments for the day, and the court is adjourned, but as noted, we will now have a 20 or 30-minute session where we will take questions from students or anyone here today, and we will try to answer those questions. And we've got a little housekeeping here to do, so that's great. We appreciate that.
And I just now noticed.
It's a dangerous thing. I don't know if they want to give me two.
Now, take some questions. Before we do that, I want to thank some folks again. I want to thank everybody who was up here working on things. I think it's the folks who work on your moot court team, but if I'm wrong about that, I apologize. But again, thank you very much. Thank you, Principal Dickus, and teacher, I believe Jeff Gross, who did most of the organizing for all of this. I want to thank County Court Judge Ann Payne and District Court Judge Pat Heng for their introductory efforts today. And I want to thank our special bailiff, Tucker Gillespie. Let's give him a round of applause. And with that, we will take questions. We cannot answer questions about the specific cases that were discussed today. There are ethical concerns about doing that, so we will take questions. But there's one thing I want to do before we do take any questions, and Justice Stacy has a kind of special introduction that she wants to make today.
So I told you that my judicial district is in Lancaster County, but a long, long time ago, I started kindergarten at North Ward Elementary and went through first grade before we moved to Lincoln. And both my folks lived and grew up in McCook. My dad, Larry Frazier, is on the Distinguished Alumni Wall. I got to stop and visit him on the way in. And my mom, Annabeth Frazier Cox, is here with us today. She made the road trip. This is the first time that she's been in the McCook High Auditorium since she graduated from this school in 1957. So I'd like to introduce my mom, have her stand up. Hi, Mom. Thank you for having us. It's been a real honor.
With that, we will take some questions.
Are there microphones up there, Chief? Oh, okay. Bear in mind, it's really hard for us to see.
That's right.
We can't see you.
So if you've got your hand up,
When we go to the law schools, there are some professors who give extra credit to their students who ask questions.
that's a hint. Okay, do we have a system here?
What experience would you need to do something similar for what the court does in our future?
Okay, anybody, what?
I didn't hear the question.
Can you give us the question again? I'm sorry.
What experience would you need to do something similar to this court in our future?
Okay, your question basically is, what experience do you need to be a lawyer and ultimately to be a judge? Is that a good?
Yes.
Very good. Anybody want to take that? Don't be bashful.
I'll take that question. Can you hear me okay? So to be a lawyer in Nebraska, you have to get through high school, so hopefully you're all on track to do that. You need to get an undergraduate degree in really any field that you think is interesting and you want to work hard at and get good grades. Then you need to apply for law school and attend a law school and graduate. And you have to pass a bar examination, which is a test after you finish law school to determine if you are competent to be an attorney in Nebraska. If you are, and you pass that test, you become an attorney. So we all are attorneys in Nebraska. Be a judge, then you have to take the next step when the vacancy becomes available because of a retirement or a resignation or a death. You have to apply to be a judge. You go through a vetting process with what we call a Judicial Nominating Commission, which is a group of lay persons and attorneys who decide if you're qualified to be a judge. And we just did one, I did 2 in October out here, one for McCook and one for North Platte. So Judge Pat Hang is recently appointed to fill a vacancy in McCook. If you get through that process, that vetting process, then your name gets passed to the governor, and the governor will do an interview with you, and then he will determine of the candidates he's given who should be appointed as the judge. So we have all done that process. Some of us have done it several times based on different levels of the court that we started at. I started as an attorney in Nebraska City, as a prosecutor and a defense counsel and a private attorney. And then I became a county judge, then a district judge, and now to the Supreme Court. So all that time I gained a lot of experience of how to be a lawyer and how to be a judge. And then coming here, that ramps up to being an appellate judge and reviewing cases to see if it's done correctly. And so that's the experience I have. We all have somewhat unique backgrounds from our practice days as attorneys, but we all kind of ended the same place. To be a judge in Nebraska, you have to be at least 30 years of age, you have to live in Nebraska for at least 5 years, and you have to, as I mentioned, be a lawyer. So that's some of the background to all of us.
Okay, do we have another question?
So my question is obviously you guys are judicial branch, and so you interpret the law, but even more so, you're interpreting courts' decisions that have been made and what to do with them. So my question is, if you had to, what other branch would you serve in, other than the legislative or executive branch?
We've never gotten that question.
I heard all of that till the very end.
So if we were not in the judicial branch, which of the other 2 would we choose? Is that?
Yes, correct.
Okay, good question. Anybody?
I think all 3 of them have very important roles in our system, and they all have appealing and unappealing portions to them. I've been fortunate that I worked in the Attorney General's office before I joined the judiciary, and as such, that's part of the executive branch. But part of my job there was actually helping write and review and talk to legislatures about legislation. So I've got to work in all 3. So I'm very fortunate in doing that. Like I said, each of the branches has its pluses and minuses. And I think it's probably individual for each one of us what we would think was the best one. Since I'm here, I'm going to say this, but if not, I enjoyed my time in the executive branch, but I also enjoyed my time working with the legislature. So,
Anybody else?
I would just say I've been in the judicial branch now for 30 years, and I don't think I have any desire to be in either of the other 2 branches.
I'm going to join Judge Castle in that regard. I went on the Court of Appeals in 1992, and I got this job in 1998, and I am not suited to be in the legislature or the executive branch.
Well, you will see a lot of attorneys in the legislative branch. And so if you go to law school and you want to serve your community or your state, and it doesn't mean you have to be a judge, you can do that in the executive branch or the legislative. But a lot of the bill writing and the laws, it helps to be an attorney and to aid in that discussion so that you understand what the import of the law is, the effects of it down the road. So we like to see a lot of legislatures having law degrees because they have a good background of spending time in law schools.
So one of the things that this question points out is a law degree gives you entry to all kinds of possibilities in your future. Not every one who goes to law school and has a law degree ends up actually practicing law. It might be an entree to many different kinds of professions. And the other comment I would make is in some other states, judges are chosen in different ways. In most states, for example, or at least a majority of the states in the United States, judges are elected just like you would elect a county commissioner or a state senator or a governor. And that makes for some very interesting situations. For example, the current governor of Texas, at one point in time, was an elected member of the Texas Supreme Court. So you can move on to other branches of government.
Thank you.
Thank you.
Appreciate
Good
it.
question. Who's next?
Hello.
Yes.
All right. I actually have, well, a few questions, but one that you just brought up is really interesting. So obviously Nebraska uses the Missouri plan to select its justices.
Good work.
Do you view that as the best system, or do you think that electing judges has its merits?
I will take a crack at that. I always say there's no perfect way to select judges. For me, at least, the disadvantage of electing judges is that judges, if they have to run for office, they have to raise money. And if they're going to raise money, it is likely to come from the lawyers who practice in front of them and litigants who have a lot of litigation in front of a particular judge. And that almost immediately raises concerns about whether or not a judge can be fair and impartial. Some people will say that the process we use, the Missouri plan, as you noted, that we've talked about already, takes politics out of the process. I do not think that is the case. It just changes the politics. But for me, again, the good thing is judges don't have to raise money in this system.
I would add to what the chief said, a historical note that we are actually more Missouri plan than Missouri is, because Missouri does not select all of their judges by the merit system, but Nebraska does. Every judge at every level, including specialty courts such as the Workers' Compensation Court, are selected under the merit plan. And when you look across the country, there are a few states, not very many, but a few that emulate the federal model, which is appointment on good behavior or essentially for life. And that's one extreme of the spectrum. The other extreme, as the chief indicated, is those who are elected routinely by contested partisan political elections. The important thing, I think, and now I'm speaking for myself here, is that you take politics out of the system so much as is possible, but yet you retain the ability to hold judges to account for their performance in office. And that is why the retention election feature that we have, and several of us on this court are up for retention election in November of this year, is a very valuable feature. Even if it's not used very often, because most judges are retained, it still provides the escape valve for the rare instance where a judge should not be retained. Great question.
And it allows the citizens in the community where the judge serves to make the decision about whether that judge should be retained or not. There's a cadence to those retention elections. In Nebraska, the first time you will stand for retention is the first general election 2 years after you've been appointed. So that's kind of a short fuse, and it lets the folks in the community weigh in on how that judge is doing pretty quickly after appointment. If a judge is retained at that first retention election, then the law requires that they stand for retention every 6 years thereafter. And so it is not a system where once you are appointed, it is a lifetime appointment. But it requires people like you, when you go to the polls, to get all the way down your ballot, flip it over, go past the weed control folks you're voting for, because the judges are on the back page at the very bottom. And not everybody gets that far. But it's an important issue for you to weigh in on. And a lot of people wonder how they can get informed. How do I make an informed decision on judges who are up for retention? And there are several different ways you can do it, but one of the very best ways you can do it is to go to your courthouse in your community, walk in and sit down in the gallery and watch the court proceedings. Watch how that judge manages his or her docket, how they decide the cases that come in front of them, how they treat the litigants and the lawyers, and incorporate that into your decision. We also have polling, if you will. That's the wrong term for it, but we have a survey that the Nebraska lawyers complete every 2 years, and they are asked a series of questions about the judges before whom they regularly appear, and those results are published and made available on the Nebraska State Bar Association's website and on the Nebraska Supreme Court website. So that is another resource for you to check.
And then I just have one more question. So I'm an admitted law student at UNL Law, and I'm incredibly fascinated by constitutional law. Want to go into that field one day. What would be the biggest piece of advice that you would give to someone who is entering law school this fall?
Wants to do constitutional law, or?
Yes, specifically that.
Read the Constitution. I say that somewhat flippantly, but a lot of people that are interested in constitutional law spend a lot of time reading about the cases that the U.S. Supreme Court has decided, and those are very important. You have to read them and understand them to understand how constitutional law works in the United States. But you also have to remember this all springs from a document that was ratified by the people and has been amended by the people, and the words that they used and the words that the people ratified matter. And so my advice would be read the Constitution.
Once you have the vocabulary of the Constitution, it'll help you as you read opinions and precedent and so forth. We go back to school for at least 10 hours a year. We were recently at an appellate seminar, and I asked a question of a professor, dean, and it had a constitutional component to it, and I referred to privileges and immunities. And then my brain kind of kicked in, and it's just like gets to be a muscle memory that you know the language of the Constitution.
One thing I would add to what my colleagues say is that several folks here have referred to Constitution in the singular. Remember to refer to it in the plural. Nebraska has a Constitution, and any lawyer practicing in Nebraska needs to not only understand the United States Constitution, but the Constitution of the state of Nebraska. And I would venture to guess that amongst the public at large, there is a much greater understanding of the U.S. Constitution than there is of the Nebraska Constitution. And in your daily lives, the Nebraska Constitution is likely to have more actual direct impact than the federal Constitution.
Thank you so much.
Good luck.
Thank you. Next
So,
question.
The Chief Justice mentioned briefly biases coming from campaign funds for being up for re-election. But my question is, how do you all as the court control your biases when you're actually hearing these cases and maintain a fair and impartial opinion? Because obviously all of you have your beliefs, religious, moral, or political, and how do you maintain or sort of compartmentalize those in order to really just decide based on the law?
Very good question. Essentially is we all have biases. How do we as judges compartmentalize those biases and be fair and impartial in each case in which we participate? Anybody?
Well, going back to the previous questioner's discussion of a law school experience, I think that is one of the places where understanding what is required of a judge is acculturated into those of us who end up serving on the bench. And above and beyond that, it becomes a question of integrity. And I will say, when I was a practicing lawyer, the pressure on being a lawyer is primarily external, in the sense that you are responding to your client's wishes, hopes, and desires. But when you go on the bench, the pressure is internal, and the pressure becomes to do what we are supposed to do, and that is to disregard those biases or prejudices and decide cases and issues solely on the law and the evidence that's been presented. It's a challenge, but all of us deal with that every day.
We all took an oath to uphold the Constitution of the state of Nebraska and the Constitution of the United States, to set aside our prejudice and our bias. We all pledge to be true to the rule of law. It's understanding our role in government. We have the three branches of government. We have separation of powers. We have checks and balances. Our job is not to legislate. We don't create the law. We don't enforce the law. We interpret the law and apply it to facts of the cases. And we issue opinions and orders that we expect people to carry out. If they're going to carry that out, they must have faith in us. They must believe that we are doing those things we promised we would do. We are setting aside our prejudice and our biases, and we're deciding the law based on what the law is, not what we think it should be or what we want it to be. We have to apply it as it is. And if we were to do it our own way, our own thoughts, our own opinions, we would lose credibility in the public, and the public would stop listening to or abiding by our orders or our opinions, and we would become an ineffective and a hollow branch of government. So it's as crucial of what we do every day as anything else, and more importantly, perhaps. And if we ever lose that, then the citizens of the state should say we're not doing our job, and they can take steps to alleviate that problem. So it's vital to what we do, and it's a challenge, and it's something we have to work on, but we all pledge to do that.
We have a judicial code of ethics that gives us the guardrails. You know, we don't have to make this up on our own every day. We check our own thought processes, our own prejudices, biases every single day. But there are certain times where we know that the code of ethics would require us to recuse ourselves from a certain case. And so there are times when you can't set those things aside and compartmentalize them. You recuse yourself from the case so that you are not part of the decision.
And I'm sorry, but that led me, your comments led me to a follow-up question, and that's, does the politicization of this just judicial system as a whole make that challenge harder of actually maintaining that integrity and setting those aside when we're electing judges based on their political beliefs?
I think it's a credibility issue. I don't know that the judges that sit here today are working harder because of the politicization of the system, but I think we have to make sure that we portray that to the public so that they maintain confidence in us. And if they see us as a shell of one political party or another, then we become that ineffective branch. And so there is a danger to that, and the decision makers who appoint us have to consider that as well when they're making their decision of who they appoint to this bench. They can't just appoint one party or the other. They have to look at their educational background. They have to look at their work experience. They have to look at their judicial temperament. They have to look at how they treat people, how they work with people in their community. You want people in your community that you know and trust to make these types of decisions, and that's why it's important for us to come out and meet with you all today, so you understand who we are, and you understand that we're not some bureaucratic political machine in the Capitol. We're not that. We are people from all over the state. We come from areas that are similar to yours, and hopefully we've been vetted by sufficient enough people to ensure that we don't fall into that politicization of the government and the judicial system as a whole.
One of the other folks on your wall of honor in the other room, in addition to Justice Stacy's father, is former Governor and U.S. Senator Ben Nelson, who came from McCook. And I've been appointed to 3 different judicial positions, to the district court bench by Governor Nelson, to the Court of Appeals by Governor Johans, and to the Supreme Court by Governor Heinemann. That willingness of governors to appoint people from across party lines is, I think, essential to the public confidence, and consequently, Governor Nelson, I suppose one of my biases would be I'm really glad he did appoint me, as he also appointed my colleague, Judge Miller-Lerman, and I'm probably a little biased in his favor for starting me in my judicial career.
Thank you.
Thank you. Another question.
Okay, so you mentioned recusing yourself from the court. Can you kind of explain that process a little bit and maybe provide some specific instances in which that would be necessary?
Sure.
Very
So
good, yeah.
any judge at any level will recuse him or herself from a case where the parties are a relative, right, within a certain degree. Anytime you have personal knowledge about the case, you may know the folks involved. They maybe went to school with your children or something. If there's something that you know extrajudicially about the case, you would recuse yourself. You wouldn't sit on it as a judge. If it is an issue that when you do your gut check, you say, I can't be fair and impartial on this. My personal experience is going to pull me one way, you would recuse yourself. The nice thing about being in Nebraska is another judge would step in and hear the case. You're not stuck without a judicial decision maker. So at the trial court level, another trial judge would come in and hear the case. At the appellate level, we have cases during every call where one of us is recused for some reason. Sometimes we were involved in the case when it was down in the lower courts. Sometimes we know a party. And when that happens, if we need a full court to hear that case, the chief issues an order and we call up one of the district court judges to sit with us. And that happens every now and again. And so that's how we handle recusals. It is not an unusual or an extraordinary thing for us at all. Every judge does it pretty regularly.
I am probably the one who's recused the most recently. In my prior employment with the Attorney General's office, I did have a large number of cases that I was involved with that were coming before the Supreme Court, and as such, I've had to recuse out of all those cases. Even if I was very tangentially involved in those cases, it would have an appearance of impropriety. It wouldn't seem fair to the person on the other side that at one point in time, my name was on the case going against them. So in those situations, to make sure that the system seems fair and is fair, I go ahead and remove myself from those cases, and my colleagues will then rule upon those cases as they come through.
Awesome. Thank you, guys.
Thank you very much. Other questions?
We have it.
What is the advantage of being a judge like at a higher level court like the Supreme Court versus being a judge at like a lower level court?
Very good question. What's the difference of being an appellate court judge as to a trial court judge?
Well, we get the last say. So we're not last because we're right. We're right because we're last. But we still try to do our best job to always make sure we get it right in every situation. The advantage you get from being up here is we have more time to think about the issues and to try to do deep research and deep thought and consult and do everything we need to do to make sure we do get it right. A disadvantage of that is there's a lot of pressure. There is no one behind us to just check our work to make sure we did. And if we were to make a mistake, then that mistake goes forward and affects not only the case for the litigants before us, but also cases going in the future.
And actually, there is no other system, either in government or outside of government, to my knowledge, in the United States that goes to the length that the judicial system does to ensure that errors are given an opportunity to be identified and to be corrected. And many times that is long after the initial decision has been made. There is a great deal, certainly more than the medical profession, which I admire. My daughter is a doctor, but they do not have that system of checking error that goes to the same extent that the legal profession and judicial system does. And we're very, I think, thankful for that kind of system.
The other thing we get to do, the 7 of us, is part of what we call the administrative operations of the court. So we have a lot of court personnel here today. We have courts in 93 counties, district and county. We have probation that we oversee. So the 7 of us get to, and it's a privilege, to help steer the judiciary in the direction it's going. So Judge Castle is our technology person. So when we have ideas to better our technology use across the state, he leads a committee of attorneys and judges and lay people to better technology. I get to work with probation and problem-solving courts. And so that's another benefit of being here, that the judges in the trial court don't have as much say. They get to be parts of those processes, and we take their input, but the ultimate decision has to be with us. And so that's, I think, a responsibility that we all take very seriously, but I think we all enjoy doing, because we like to see the judiciary moving forward and going the right direction, and so we like to be a part of that.
Another question.
Thank you.
That's thinking.
So what events led to the Nebraska Supreme Court to come to McCook Senior High for these cases?
What events took place to lead us to McCook High? Well, we've been trying to get to McCook High for, I think this is the 3rd year. We had this awful pandemic that came along and sort of got in our way, but we typically nowadays go to at least 3 high schools a year for oral arguments. Most of our oral arguments are in the state capitol building in Lincoln. So in the fall, we try to get to a high school in greater Nebraska, so we see if there's a high school that's interested. Sometimes we ask, and we have been to Norfolk and Beatrice and Schuyler and Grand Island and Scotts Bluff and Hastings, and twice a year we go to law schools, one to the UNL Law School and one to Creighton. When we go to Creighton, we always try to also, in the afternoon of that day, go to an Omaha metropolitan area high school. And then again in the spring, we try to get to greater Nebraska, and that is why we are here today. So McCook, of course, is a great town. You are the sort of regional capital of southwest Nebraska. I jogged this morning down Norris Avenue, and you have lots of great history here. Reference was made to Ben Nelson, and Frank Morrison is from the, at least from the McCook area, and George Norris, of course, has tremendous historical significance for Nebraska, and this is his hometown. And you also have great architecture. As you're aware, you have the only Frank Lloyd Wright House in Nebraska, and you have beautiful buildings downtown, the old federal courthouse and some of the other buildings. So I guess the ultimate answer to your question is, if we were going to come to southwest Nebraska, McCook is the place to come, right? Thank you.
Thank you.
I have a question regarding the public's perception of partisan influence and appointments to the court, and more specifically to the U.S. Supreme Court, but it may fall back to court appointees in Nebraska. And that is, my question is, if you make an assumption that we are appointing younger and younger court, or judges, excuse me, and I'm here again, I'm seeing this influence at the U.S. Supreme Court level. what is the advantage of a lifetime appointment? And should we consider, or how do you feel about considering term limits that might be in the neighborhood of, I'm just suggesting 10 to 15 years? Thank you.
There you go. Question on the systems that are used to appoint judges, and we've talked a little bit about that earlier, and politicalization in that appointment process. Anybody?
One of the things we didn't talk about when we were giving you the 50,000-foot flyover of the judicial appointment process is the Judicial Nominating Commission makeup. And under Nebraska law, it is required to be a politically balanced committee. There have to be an equal number of Republican members and Democratic folks who are registered Democratic, and that holds true whether it is an attorney member or a citizen member. And so it is precisely balanced, those committees that interview the applicants, that ask questions of the applicants, and that make that threshold decision about which judicial applicants are qualified to move forward and be considered by the governor. So unlike a federal appointment process, the appointment process in Nebraska, the vetting process, is required to be politically balanced. In fact, if we get into a nominating commission and one person has changed their party affiliation, we've got to do it over. So that is one of the controls, I guess, in our system that I don't know that we talked about previously, and I think it's important, and I wanted to mention it. I'm not sure it answered your question, but I deflected.
I think one of the concerns we have as well is the applicants for judicial vacancies, those numbers are decreasing. We don't see, so when I applied the first time in 2007, there was 13 or 14 people that applied for me for that same position. Since that time, I've seen the numbers go down, and oftentimes there's 2 or 3 or 4 candidates that will apply for a vacancy. These jobs are challenging. They're very public. People see your work. People have lots of opinions about your work. And some attorneys don't want to take on that additional responsibility or scrutiny. They just prefer to be a lawyer and have a successful practice. And they are not putting their names in for judicial vacancies. So that's a concern we see. And if we have term limits, I would imagine that those would be similar to a legislative term limit. So every 4-year term and another 4-year term, and then the judge would be out. So every 8 years, you'd be switching judicial appointments in your district. And that may be difficult to replace. And you may be changing a judge just because of a term limit, not because of the quality of the work that judge has done. And that's why the retention vote is so important. If you are unsatisfied with your judge or community, then you have an opportunity to vote them out at their retention. And so I think this is a process that we have that's in place that has worked. I think it will continue to work. And I don't know the answer to how we get more people to apply for vacancies. Part of that's less attorneys in rural parts of the state. So I'm in southeast Nebraska. We've seen less and less attorneys in southeast Nebraska. We've seen more attorneys in Omaha and Lincoln. You'll see that out here as well, and North Platte and Scotts Bluff, and all of the parts across the state, the numbers of attorneys are going down. So if we begin to have term limits for judges, I'm concerned about having enough applicants to fill those spots when those term limits come up.
To the extent that your question sought our opinions regarding what the federal system of selection of judges is, I would point out that we in the United States have a federal system of government that features 2 sovereigns, the sovereign states, the state of Nebraska, and all of the other states that have been admitted on equal footing with the original 13 states that formed the Union, and then the federal government is itself a sovereign entity. And as a functionary of the state sovereign of the state of Nebraska, I don't think I have any special expertise or anything really to contribute to what the federal system ought to do, and that selection process is by Constitution vested in the President and the Senate for good behavior, essentially for a lifetime appointment, and to change that is in the hands of all of you who are citizens of the United States.
Okay. Other questions? We've got time for.
I'm going to add one more point to something that, if that's all right, Chief.
Certainly.
To something that Judge Funk said. He said that we have fewer and fewer attorneys in certain parts of our state. We've got something like 13 counties with no lawyers in Nebraska. And we need more smart people to go on to law school, get a degree, and then come back to their hometown and practice law. The people in your community need more lawyers. The judges who are appointing people to represent litigants in the courthouse need more lawyers that they can appoint. The legislature needs more lawyers to help us enact good laws. So if any of you out there are thinking about law school, if you're the kind of kid who reads the back of the game box to be sure you know all the rules, think about law school. Think about law school, and then come back to McCook and practice.
Very good.
Okay,
Next question.
I think I'm the last one for today. I was just wondering what the most challenging part of your job is.
Anybody?
Well, there's a lot of reading. So to get ready for an oral argument, we read, all of us read literally thousands and thousands of pages. Some of it is briefs, some of it is the record that was created below, some of it are additional cases that we think we need to have a better understanding of before we go into the oral argument so that we can ask questions that will matter to our decision-making process. So it is a lot of reading, more reading than in any of my prior jobs.
I would say the decisions we render on these opinions, or these cases, is very challenging. You have to understand that they have percolated up the system for years and years. So you've had litigants trying to settle their own dispute. They can't get it settled, so they go to attorneys. Attorneys try to settle their dispute, and they can't get it settled, so they go to trial. The trial court or the jury hears the case and decides the case, and it still isn't to the satisfaction of the parties at times. They come to us or the Court of Appeals and ask us then to interpret the law and to answer these questions and make a determination. So lots of hardworking, smart people have worked on these cases before they ever come to us. If there was a simple solution, it would have been done a lot earlier. It would have been done quicker, would have been done less expensively. So when they come here, there's sometimes just no great clear path or answer to it. And that's why I'm very thankful that I have 6 colleagues on this bench that we can share our thoughts, our experiences, our knowledge of the law. Some of us have stronger areas of the law that we feel comfortable with, and so we may bounce off another area with another judge. If one judge had to make these decisions, I don't think that judge would be very long in that job. I think they would probably say that's too much stress. I am fortunate I have 6 colleagues that I can bounce stuff off of. I get their input. I'll write an opinion. I share the opinion with them. They all review it. They give me their thoughts. It's not just the duty of working on my case. It's the duty of working on everybody else's case, and then they're working on my case. So that's a challenging part, I think, of this job, is to try to make the decision. And then when you make the decision, you're not just settling the dispute that's before you. You're settling what the law is and how it's going to be applied in another case down the road. Judge Castle likes to say, we're not writing about this case, we're writing about the next case, that we don't even know what it is yet. We don't know what the facts are. And we don't know how our decision today is going to be interpreted and applied down the road. And so that's a very challenging part of this. We don't want to say, the wrong thing just to settle this case and then have it be misused by practitioners or litigants down the road. And so that, to me, is a very difficult part of this job. And so I am thankful that we have really good people that I get to work with every day that give me their thoughts, and there's no egos. There's not a you're wrong and I'm right. We talk about it. Civil discourse. We have great consultations where we share thoughts together, and nobody walks away offended. We may end up disagreeing, but nobody takes it personally. Nobody we're not going to talk to that judge now for the next week. We go out and have lunch afterwards, or we work on other cases together the next day. So that, I'm thankful, because that's the hardest part of the job for me.
I agree with everything Judge Funk said, but I would put it a little more simply. That is, the most challenging thing is to write a decision that says what it needs to say to decide the present case, but does not lead to a potential for unintended consequences. And that is a hard job.
So there's challenges in terms of lifestyle, and there's challenges in terms of subject matter. And as Justice Castle said, with respect to this subject matter, stick to this case and don't say more than you need to. With respect to kind of a lifestyle challenge for a job like this, it might be at the appellate level a bit isolating for some people's temperament. And as Justice Funk has indicated, because we consult with each other quite a bit, you need to play well with others.
And that's why we like coming out here, because then we can have some socialization and get to see you all.
Just coming to see some people.
Thank you.
Okay. I think this probably, we better wrap it up here. So again, I want to thank everybody at McCook High, all of you bisons out there, and really everybody in the McCook community. This was great, and we greatly appreciate it, and I think we're going to have lunch with some of you. So thank you very much.